Hi, good afternoon, everyone. Welcome to today's webinar. Thank you for attending. I guess I've had a busy week, so don't mind me if I end up trying to say something and I stutter. I have been tired for the past couple of days, but I'm going to give you all the insights into how a partnership has pros and cons and exploring the pros and cons of forming a partnership in Canada. So, this is our today's live webinar. I am Nisha Nehru, and I'll be guiding you through the key considerations, legal requirements, financial implications, and tax consequences of forming a partnership in Canada. Choosing the proper business structure is essential for success. Partnerships offer advantages such as shared responsibilities and resources, but they also come with legal and financial obligations. By the end of this session, you will have a clear understanding of whether a partnership is the right choice for your business. So, what is a partnership? Businesses owned by two or more people is a partnership. But partnerships don't only end with that. A partnership is a business structure in which two or more individuals share ownership. Each partner contributes resources such as capital, skills, expertise, and in return shares in the business profits and losses. However, this is governed by a partnership agreement. So make sure that you have the key features in this partnership agreement as shared management and decision making, profit and loss distribution among partners, legal and financial obligations vary by partnership type. So these are key features that should be in your partnership agreement at all times when you're considering a partnership. Now, the types of partnerships. Make sure that you understand these different types of partnerships. There are three primary types of partnerships. A general partnership, which gives shared responsibilities and liabilities. A limited partnership, in which some partners invest but do not manage. This is one key aspect where you will have general partner, and the general partner will be playing the management role, and the limited partnership will not. The limited liability partnerships are usually for lawyers or professionals like accountants. This is protected. This is a liability protection for these professionals. Each type has various legal and financial implications, making it important to choose the right one for your needs. So make sure when you're preparing a partnership agreement, you distinguish these types of partnerships, and you are required to do so under the legislation. So make sure to look up the Partnership Act as well as the limited liability, limited li- limited partnership act, not limited liability. That there is no limited liability partnership act, only limited partnership act and a partnership act. Okay? The pros of a partnership. Shared financial investments. This is important because you do share in every aspect. This reduces financial burden, and it allows you to have complementary skills as well. So if you're dealing with a partnership where, let's say, one individual contributes to financial responsibility, but the other one has the necessary skills to provide the equal amount of that financial burden, then it might actually work to your benefit in several circumstances. These partners bring diverse expertise. And there's tax benefits. Avoid corporate double taxation. As you know, corporations require a higher tax consequences, and in this you will reduce your tax consequences and you'll be able to limit it to yourself. Flexibility in management, fewer regulatory requirements, easier decision making, and compared to larger corporations. But remember, this is not always the case, so we will discuss this further. In this aspect, your partnership should have 1 to 4 or 5 people, then it will be easier to make those decisions in that case. However, let's look at the cons. So, cons of a partnership: unlimited liability. In so that personal responsibility is must be accepted by each partner for the business steps. This is an important factor. You will have to share equally in the personal liabilities. Profit sharing. All profits must be distributed among partners. Potential conflicts. Differences in management styles can create disputes. Limited business life. So, may dissolve if a partner exits. So let's just say if a partner either passes away or a partner decides that I no longer want to be a partner. If you only have 2 partners, if you only have one other partner and yourself, and if that other partner leaves, you're going to end up having to deal with the full business yourself. So make sure you have exit strategies in place. Difficulty raising capital, fewer funding options than corporations. So remember that these can be mitigated on several circumstances by creating a proper partnership agreement and making sure that you are actually adhering to the Partnership Act as well as the Limited Partnership Act when you're imposing these agreements. And also, if you have a partnerships where you have multiple partnerships, you would want to secure um, a bylaw or create a bylaw and prepare specific roles and create guidelines for each roles. This will allow you to have a better understanding of each partner's roles, and it will allow you to have a better decision-making process. If you create bylaws that will allow you to elect these partners, if there's multiple partners, let's say there's more than 4 or 5 partners, and you want to have a director in the partnership or an individual who's a managing partner in the partnership, sorry, not a director, managing partner, you would want to have an electoral process within your bylaws. This will help you have determine who's the managing role and who has the ability to make decisions and what roles the other individuals will play. Now let's go to the legal requirements for registering a partnership. Register the partnership with provincial or federal authorities. File required documents. Form 5 under the Business Names Act. Renew registrations as required by law. Industry-specific regulations may apply. So it's always good to consult with a lawyer before you actually register to make sure that you're adhering to all the requirements in the registration. As you are aware, the drafting a partnership agreement, you might want to make sure that you clearly outline roles, profit sharing, decision making, and exit strategies. These are important because if anything happens to one partner, you need to know how their shares will be divided or how it will be distributed. Will it go to the partner's spouse, or will the shares will be brought back or bought back by the partners, and how you would do the exit strategy for this partner. So those are things that you need to consider. Liability protection. Consider LLPs or LP structures if limiting liability is essential. However, remember, this will only apply to the partner that is under the limited liability. So if the other general partner, who is going to be the managing partner, will end up having those responsibilities and will incur liability. So make sure to determine those aspects and clearly define those aspects in your agreement. Registration requirements. Partnerships must be registered with the provincial or federal authorities. These are things you will have to look into because there are some requirements by law that you will have to file, like tax forms, as indicated in this slide. Regulatory compliance. Some industries have specific partnership rules. So make sure that when you have regulatory requirements, you are adhering to their requirements. If they require you to provide filings or even indicate how your decision making process is going to be allocated so that they can determine who is the authorizing individual, you need to be able to decipher these, and you need to be able to clearly put these information into the partnership agreement or the bylaws as is necessary. Okay, so let's go to the next step. So I am going to again reiterate how a partnership is formed and how it is determined as per Spire, Freezer Limited, and Canada. In this case, they determine that a partnership is identified as carrying on a business in common for the view of profit. Remember, even if you're not sure, if you are carrying on a business together in common and you are doing it for the view of profit and you have an agreement with your partner, that could constitute as a partnership, even if you haven't determined it as a partnership. Although you might have not defined the terms of the partnership, this is still relevant in determining whether a partnership exists, especially if this matter goes to trial. So look at all the partnership acts and determine if you fall within those categories, determining what a partnership is. And if you're actually complying with all the regulations and the statutory requirements, then you might actually fall into that category. However, if you're doing a co-venture, which is not a partnership, but you're sharing the responsibility equally, but you're not actually distributing it amongst each other, then it might not be considered a partnership. As if you think about the example that I provided in our last webinar, if you have a taxi cab or a house and you decide that you are going to only take the 50-50 percentage and you have no other relationship other than the fact that you're sharing this property, then it may constitute as a co-venture unless you blur the lines and you indicate that we will be having an agreement and this is the agreement and we end up having profit, and there are other important criteria to remember. So always consult with a lawyer to determine if your agreement constitutes a partnership or if it constitutes a co-venture. In this case, again, I am reiterating this case because it is important. If you are suing a partnership, you can not only you can't sue the partnership itself because they are not an actual entity. Corporations are an entity. They can be sued because they create an identity, whereas a partnership is two or more individuals as defined. So in order to sue the partnership, you will have to sue each individual partner as well as the partnership in order to take it to court. So this is an important factor that you must understand because you will be liable personally in this capacity, or you may not, but if the end result is that you are liable. Each individual will be liable individually. Financial considerations. Remember to determine capital contributions from each partner. It is important to actually indicate these contributions within your partnership agreement. And when you set up the bank accounts as well, make sure that you understand the financial tracking and maintaining proper records for tax purposes and legal purposes is very essential for your long-term goals and to succeed in your business. Establish bookkeeping and financial tracking. Plan for expenses and debt handling. So these are things you must look at before you commence a partnership, as well as while you're commencing the partnership. Make sure to clearly understand what the rules are, how you're going to determine these, and who has the authority to sign for the banks and for any amount of funds that are going in and out of the bank account, because you will need to give bank authorization. Tax implications. Partnerships must file a T5013 statement of partnership income. Partners report business income on personal tax returns. GST HST registration is required if revenue exceeds the threshold. Consult a tax professional for compliance and tax optimization. So remember, no matter how many times you think you are able to do the tax forms, it is important to consider always speaking to an accountant who can actually provide you with proper advice as to how to file your taxes, especially since you will be filing them personally rather than as a partnership. Liability implications. GP. All partners are personally liable. Remember, general partnerships, all of them are equally liable on doesn't matter the amount of contributions, it doesn't matter if they have only come in with an expertise, they will still be liable for their roles. And like, even if it is not their role, the partnership may be liable as as individual partners, you will also be liable. In a limited partnerships, only person who's liable is the general partner, but the limited partner will be liable up to the amount of investments that they have contributed. So this is important to remember, that if you do have a limited partnership, the individual who will be liable beyond the required investment will be the general partner, because you can't have just a limited partner. You will always have a general partner there, and the limited partner will also be there, but they will not have the liability to the extent that the general partner has. Whereas limited liability partnership protects all the partners individually to the liabilities that they have contributed to. So if the liability is to one individual within that limited liability, then that partner is the only one who's going to be liable only to the extent of his actions. However, if it is a business decision, it may impact the other individuals. If, let's say, you take out a loan and the loan is for the partnership together, then that liability can be equally distributed among the individual limited liability partners. Now let's look at drafting a partnership. This is really essential because choosing a name for the partnership is important, but preparing a properly drafted partnership agreement will protect your needs, will also make sure that you are able to understand your roles and the context of the relationship that you have with each partner, as well as how your investments are divided up, and the if there is any requirements for each individual to be contributing to the debt or the liabilities in a specific manner. Choose a business name that ensures you comply with the provincial rules. So you can't have an offensive name. You can, most partnerships tend to use the names of their own names. So if you do that, you can file under the Business Names Act with no issue. However, just make sure that there is no issues with compliance. Register the partnership with the appropriate provincial and federal authorities. Draft a partnership agreement. Financial disputes can be resolved if, my apologies. Roles and responsibilities of each partner, profit sharing and financial contributions, decision-making process, dispute resolution, and exit clause. These are all things that should be considered when you're drafting a proper partnership, especially the dispute resolution and exit clause, because these will actually determine if there is conflict among the partners and how to go about dealing with each conflict. Do you have a mediation agreement? Do you have in your drafting, in your partnership drafting, have you indicated if it's going to go to court directly, or is it going to first be mediated or arbitrated? So these are considerations that should be made within the partnership agreement. It is always good to consult with a lawyer to determine whether which type of um, dispute resolution is appropriate for you, because you will never know what industry and the amount of partnership. If you decide to grow your partnership agreement can also be amended. But if you are already in the process of growing, you want to be able to secure those issues prior to the growth. So remember, it's better to start ahead and get those dispute resolution information within your partnership agreement before you end up growing, and then you have dispute resolution and you have not amended your drafting agreement to fit those issues. So let's go to the next slide. Common challenges in partnerships. Is partnership right for you? Ask yourself, do you trust your potential partner? Are you comfortable sharing financial and management responsibilities? Does a partnership align with your long-term goals, long-term business goals? Are you prepared for potential conflicts and have dispute resolution plans? Would a corporation or a sole proprietorship be a better fit? These are things to always consider when you start a partnership agreement, because remember, as I indicated earlier, if you have a dispute, if your partnership may be great in the beginning, but as financial burdens grow, as well as responsibilities grow, the partnership may not end up being a good fit. And you might see yourself in a position where it may be difficult to deal with individuals who have specific roles and are making decisions beyond the partnership agreement, or have made decisions without consulting the partnerships. So think about all of these considerations, because you will never know. When you have a partnership, it may be suitable at the time, but you will never know whether the long-term goals will be satisfying the partnership agreement that is made at that time. So be prepared to ask these serious questions. What will happen if we do not end up trusting each other? What will happen if we have a conflict or there's a potential issue that comes up? Are we able to share the financial burdens and responsibilities without difficulty in the long run? Is our relationship going to be successful and continue to grow and be able to take on new and more staffing and other responsibilities without issues if we go into the partnership agreement? So consider all of these potentials. Make sure you deal with these before you get into the partnership agreement, because partnerships can fail due to the lack of communication between the partners. Common challenges in partnerships. Disagreements over management. As I indicated, there are always going to be disagreement over management. There is always going to be some conflict that occurs, and you will need to know how to resolve it in the best way possible. So, set up management roles, set up partnership management roles, set up like subsidiary roles. Let's say you're one person is an officer who's going to be dealing with all the financial burdens. The other individual is going to be dealing with all the decision making relating to the business structure and any agreements and contracts that are being dealt with. So these are ways to decipher what your role is and how to deal with them. Set up ways to communicate each of these issues in a better better role, better um, dispute resolution situation. My apologies. Uh, I am still a bit under the weather, so dispute agreements over management role, define decision making processes, financial disputes, outline profit sharing agreements, unequal workload distribution, ensure responsibilities are balanced, exit strategy planning. So, also consider making wills and estates for each partner just as a precautionary measure, because these might become relevant if an individual passes away or something occurs with the partnership and the individual must leave or has an illness. So these are things that are important to consider, because in the long run, any kind of disputes that occur may not be able to be resolved within the partnership and may have to be taken to court through litigation, which is a very lengthy and very difficult process for some situations. And partnerships can grow to a point where you have multiple partners, in the sense that some firms may even have 15 to 20 partners. Now, who's the managing partner? Now, who's the one who's going to do the other roles? So these are the reasons why sometimes you need to set up a bylaw to be able to discuss these issues, and articles of incorporation will indicate the kind of officers who are there, who are in the roles that are need to be, sorry, not articles of incorporation, my apologies, bylaws and the structure of the partnership agreement will indicate who is going to be in these roles, what the roles are, who is going to take responsibility in for the financials or for the debts, and how the management is going to be dealt with. So these are things that are important to consider. Best practices for successful partnership. Maintain transparency. So open communication builds trust. Clearly define roles and expectations. Avoid conflicts. Conduct regular financial reviews. Keep financials in check. So make sure you always have a flow chart, and make sure you always have information put into these flowcharts. And on a monthly basis, you have meetings, schedule meetings to deal with these issues, and put them in the books. Make it a regular occurrence so that you understand what your responsibilities are, what the other individual's responsibilities are, and how to discuss them if there becomes an issue. And have a conflict resolution plan to address disputes. This could be a mediator. You can actually have a common mediator that you agree upon that you can put in, or you could just indicate that we will first attempt mediation and then arbitration and then litigation. So these are steps that you could put into the agreement that will allow you to forego any further costs and make sure that the issues are dealt with as soon and as, I guess you can't say easy, but as practically possible. So those are things to consider. Industry specific regulations. So remember that even though you have a partnership, you will have to adhere to these other regulatory requirements. These are important things to consider depending if you're in the medical field, if you're in the legal field, if you're accounting, or even if you're a environmentalist. What environmental considerations should you be providing? If you are in the industry where you drive trucks and you have partnership and you do deliveries, what are things that you should be looking at? Is there insurance requirements? Is there licensing requirements? Do you need to, who is going to be the individual who is taking the ownership? It's going to fall under the partnership, but remember, there is liability on each aspect. So these are things to be considered before you go into creating a partnership. Exiting a partnership. This is not always easy to talk about because we always anticipate that our partnerships are going to grow, get better, get more successful, and they will, or they won't. We don't know. But we always need to include exit clauses. Define the process in your agreement. Make sure that you have a will if you are an individual managing partner, especially if you own a lot of the partnership, a greater amount of the shares of the partnership. It is important to make sure you have a proper exit strategy. If you're a junior partner, it may be a different aspect to consider. That's in the legal field. But in other fields, if you have partnerships, you might want to make sure that there's insurance policies to cover in case a death of a partner. If you want to purchase the partner shares, and because once a partner dies and there is no exit strategy or exit clauses, you might end up having to have the spouse of the partner become a partner, or the children of the partner become the partner, and they may not have much idea on how the business is operated. And if they have decision making rights, it might be conflicting with the business itself. So these are things to consider. What is the importance of these like exit strategies is that it allows you to make sure that your business will be successful even if the partner has to leave or does end up dying and you can't replace the individual and there is no other partners available. So these are things to consider. And, and also understand the financial and legal consequences, impact on remaining partners, plan for business continuity. That is the most important thing. If you want to continue the business, you must have an exit clause that will allow you to continue without having issues. Role of legal financial advisors. Ensure compliance. Legal advisors help with registration and agreements. They will make sure to look at the Partnership Act, the common law perspectives, and decisions to be able to determine what the best fit for you and your industry is. This will allow you to safeguard yourself and each partner will be able to make sure that financial planning has been dealt with, regulatory updates have been dealt with, risk management strategies have been dealt with, and you have complied with all the legislative requirements, even the industry specific requirements. So these are things that are always important to consider when you're creating a partnership and when you're continuing a partnership, because your partnership may evolve over the years. You may grow where you have multiple partnerships, or you may dissolve and become a sole proprietor. So consider at each stage of your life, is it appropriate to ask for legal advice? So these, make sure to look into each stage of your life. Do not just wait until it becomes a downfall. Summary and key takeaways. Choosing the right partnership type is crucial. A well drafted partnership agreement prevents conflicts. Understanding tax and liability implications is key. Setting up partnership correctly ensures long term success. So make sure to do those things, because in the long run, you might have a more complex case where it'll take a lot longer and a lot more funds for you to actually correct the issues that you might create or that may have been created without your knowledge. I would like to thank you and for attending today, and I appreciate your time and consideration. And we will have more insights. Perhaps next week we will deal with not-for-profits and charities. But because they're very extensive, we might just give you a brief overall about what a not-for-profit organization is and what a charity organization is, and the type of legal structure that you would want to impose on them. So just stay tuned, and if you have any questions, you can contact me anytime via email at the email address provided below. And I am also available by phone at 905-267-3350. So if you do have any questions, I'll be happy to guide you. However, as indicated, if I'm providing legal advice, we will have to look into properly dealing with that as a client-based legal advice. So make sure to understand the difference. Like, information and legal advice are two separate types of information. There's two separate types of guidance. One is actual providing legal advice, where we go through your particular circumstances, whereas if you need just directions to, oh, what website should I go to, that's information guidance. Okay? And thank you for tuning in, and hope to see you next week.